Hello friends, welcome to Prashant IAS. So friends, in the last class, we were discussing about directive principles of state policy. And in this class, we will continue our discussion further. So friends, in this class, we will start our discussion with the comparison between fundamental rights and directive principles of state policy. Okay, so what is the difference between fundamental rights and DPSP? So in this class, we will try to solve the question that what is the difference between fundamental rights and DPSP. So friends, the first difference is that fundamental rights are enforceable in the court of law. That is, they are justiciable. But directive principles of state policy are non-justiciable and are thus not enforceable in the court of law. Now what does it mean? So it means that first statement says that fundamental rights are enforceable in the court of law. That is, they are justiciable. Now what does it mean? So it means that if government does not enforce any of the fundamental right, then you can directly file a case against the government in the Supreme Court of the country. And then Supreme Court will give order to the government to implement that fundamental right. And this means that you can force the government to implement a fundamental right. For example, friends, Article 16 is a fundamental right. So what does Article 16 say? So Article 16 says that equality of opportunity in the matter of public employment. Means if there is any government job in the country, then government should provide equal opportunity to all the citizens of the country to get that job. Okay, so if there is a government job, then government should provide equal opportunity to all the citizens to get that job. Now suppose friends, government is not implementing that fundamental right. Means suppose if government is not providing equality of opportunity in getting government job. For example, suppose if government is doing favor of a particular community to get that job, government is providing extra opportunity to some people for getting that job. Okay, and on the other hand, government is discriminating against a section of people. Government is not giving any opportunity at all to some people to get that job. Okay, so now friends, the people who are not getting opportunity, okay, the people who are getting deprived of the opportunities, they people can directly file a case against the government in the Supreme Court that government is violating our right to get government job. Okay, equality of opportunity in the matter of public employment. Government is violating our Article 16, fundamental right under Article 16. Then what Supreme Court will do? Then Supreme Court will issue a writ against the government, and then Supreme Court will give order to the government to implement that fundamental right. Okay, so it means that if government is not enforcing any fundamental right, then you can force the government to implement that fundamental right. You can put a case against government, you can file a case against government in the Supreme Court. But friends, the second thing is that DPSP are non-justiciable and are thus not enforceable in the court of law. Now what does it mean? So it means that even if government is not implementing any DPSP, even government is not taking any step to enforce any DPSP, then also you cannot file a case in the court against the government. Okay, and you cannot force the government to implement DPSP. So it is up to the choice of the government. It is just an option for the government. So if government wants, then government will implement DPSP. And if government doesn't want, then government will not implement DPSP. Means you cannot force the government to implement DPSP. So this is the first difference. So first difference is that fundamental rights are justiciable, but DPSPs are non-justiciable. Means you can force the government to implement fundamental rights, but you cannot force the government to implement DPSP. Now what is the second difference? So second difference is that fundamental rights are negative obligation on the state, whereas DPSP are positive affirmation on the state. So fundamental rights are negative obligation on the state. So what does it mean? So it means that they prevent the state from doing few actions which are not in the overall interest of the society. Okay, so what does it mean? It means that fundamental rights stops the government. Fundamental rights stop the government from doing few actions, from doing few tasks which are not in the interest of individuals, which are not in the interest of society. Okay, so fundamental rights are like a burden on the state, are like a burden on the government. Why? Because they are stopping the government from doing certain works. Okay, but friends, DPSP are positive affirmation on the state. Okay, now what does it mean? So it means that state has to achieve the goals given in part 4. Okay, so in part 4 of the Indian Constitution means under directive principles of state policy, some goals are given, some aims are given, and government has to achieve these goals. Government has to realize these goals. Okay, so government has to achieve these goals. It means that directive principles of state policy are not stopping the government from doing anything. So DPSP are not like a burden. Okay, they are not like a burden on the government. Okay, so it is just optional for the government. So if government wants, then government will implement these goals, and if government doesn't want, then government will not implement these goals. So these are not burden on the government. Now, what is the third difference? So, third difference is that fundamental rights provide for political democracy. Okay, but DPSP seeks to achieve socio-economic democracy. So, the third difference is that fundamental rights promote political democracy. Now, why do they promote political democracy and what does it mean? So, it means that they are enforced as a right against the state or political dispensation. Means fundamental rights are guaranteed to citizens against the government. They are guaranteed to us against the government. Means they protects us from government, okay, from many actions of the government. For example, friends, what is Article 21? So Article 21 is a fundamental right. And Article 21 says that no person shall be deprived of his life or personal liberty except according to the procedure established by the law. Now, what does it mean? It means that Article 21 actually stops the government. Article 21 actually prohibits the state from snatching the personal liberty of any individual, from imprisoning any individual, from killing any individual. And if government wants to kill any individual, if government wants to imprison any individual, then government has to do so according to the procedure established by the law. So it means that it is actually promoting political democracy. Why? Because it is enforced against the government. It is stopping the government from taking the life of individuals, from taking the personal liberties of individuals. So fundamental rights actually promote political democracy. But friends, on the other hand, directive principles of state policy promote social democracy and economic democracy. Now, what is social and economic democracy? I have already taught you this. Okay, so if you want to know what is socio-economic democracy, then you can watch previous lectures. There I have explained you that what is social democracy and what is economic democracy. So here we just need to understand that political fundamental rights promote political democracy, whereas DPSP promotes social democracy and economic democracy. Now, what is the fourth difference? So the fourth difference is that fundamental rights represent something that is static. Since the basic rights under part 3 have been conferred on individuals and the aim is to preserve these rights. Whereas friends, directive principles of state policy represent something dynamic, where the state has to do much and constantly to achieve the goals in part 4 of the Indian Constitution. Now what does it mean? So friends, this difference is little bit technical, so I will explain you this with the help of an example. Now friends, we know that what is Article 17. So Article 17 is again a fundamental right. And what Article 17 says? So Article 17 says abolition of untouchability. Sorry, here we will take the example of Article 18. Okay, so what is Article 18? So Article 18 is abolition of titles. Means government will not provide any title except military and academic distinctions. Okay, so means state is prohibited from providing any title. Government cannot provide any title except for academic distinctions and military distinctions. Okay, now friends, to achieve this, okay, means to achieve Article 18, what government has to do? actually government has to do nothing. Why? Because if government will not provide any award at all, then also Article 18 is achieved. Why? Because finally Article 18 is stopping the government from providing any kind of title. So just government has to keep in mind that we should not provide any kind of title to the people. Okay, means to achieve the fundamental right, government has to do nothing. Means they are static in nature. Government doesn't need to do anything to achieve fundamental rights, or the efforts needed by the government to achieve fundamental rights are very less. Okay, so whenever government makes any law or policy, then government just need to take in mind that government should not violate the fundamental rights. Okay, so whenever government makes any law or policy, just government need to think that whether this law is violating this any fundamental right or not. So government just need to ensure that any law or policy should not violate any fundamental right. So we can jump to the conclusion that efforts needed to implement the fundamental rights are very less. Actually, government has to do nothing to implement fundamental rights. Okay, that is why fundamental rights are static in nature. But friends, on the other hand, directive principles of state policy are dynamic in nature. Why they are dynamic? So here we will take the example of Article 45. So friends, what is Article 45? So Article 45 instructs the government to provide free and compulsory education. Now friends, to provide free and compulsory education, you can guess that government has to spend a lot of money. Government has to put lot of efforts to build the infrastructure. Why? Because schools are needed to provide education. Teachers are needed to provide education. So government has to spend a lot of money to build schools. Government has to spend a lot of money to give salary to teachers. Government has to appoint many teachers to provide education. Okay, after that government has to spread the awareness. Means government has to do advertisement of education. That education is very necessary. Why? Because in earlier times what was the practice? That people didn't think that education is necessary. For them it was useless. So awareness was needed. And for awareness advertisement is needed. Means government has to put many efforts to implement the goals and principles which are given in directive principles of state policy. Means government has to do many works to implement DPSP. That's why friends, directive principles of state policy are dynamic in nature. Then friends, let's discuss about fifth difference. So what is the fifth difference? So fundamental rights promote welfare of individuals, hence they are personal and individualistic. Whereas directive principles of state policy promote welfare of community, hence they are socialistic. So again I will give you one example so that you can understand it very easily. Now friends, what is Article 17? So Article 17 says that abolition of untouchability. Means any person or even the government cannot practice untouchability in any form with any other person. Okay, so Article 17 actually abolishes and eradicates the untouchability in all the forms. Okay, now friends, this right to untouchability is provided to individuals. This right is not provided to entire society. This right is not provided to entire country. This right is provided to every person of the country. Okay, so this right is not provided to society. This right is provided to individuals at the personal level. Means if government or any other person will practice untouchability with any person, then that person can directly file a case in Supreme Court against government and the person who is practicing untouchability with him. Okay, so means fundamental rights are provided to individuals. But friends, on the other hand, directive principles of state policy are provided to entire society. Okay, their aim is to establish a welfare state. So directive principles of state policy promote welfare of community. Okay, their aim is to make India a welfare state. Hence, they are socialistic in nature. Okay, so they are not provided to any individual. They are provided to entire society. They are provided to entire nation. For example, friends, Article 39 Clause C says that state should ensure prevention of concentration of wealth in few hands. Okay, so if the concentration of wealth will be prevented, if government will prevent the concentration of wealth, so definitely it is not, it will serve to it will serve to entire society. So it is a benefit of entire society. Okay, so if the concentration of wealth is prevented, then this wealth, this money will give benefit to entire society. So the goals and directive principles of state policy are designed in such a manner so that they can give benefit to entire society. Then friends, then comes sixth difference. So what is sixth difference? So fundamental rights do not require legislation to achieve them. But directive principles of state policy require legislation for their implementation, as they are themselves not automatically enforceable. So this is very simple. So it means that fundamental rights are automatically enforceable. Nobody can violate fundamental right. Even government cannot violate fundamental right. They are themselves enforceable. Okay, so they do not need any legislation for their implementation. No law is needed, no separate law is needed for their implementation. Okay, so if government or any other person violates the fundamental right of any other person, then that person whose fundamental right is violated, then he can go to Supreme Court, and then Supreme Court will give him relief. Means fundamental rights are automatically enforceable. They are automatically justiciable. There no separate law is needed for their enforcement. But friends, on the other hand, directive principles of state policy are not automatically enforceable. Suppose there is no law. Okay, suppose there is no law to protect any DPSP. For example, Article 39 Clause D says that state must ensure equal pay for equal work for both men and women. Means if men and women are doing same work, then they should be provided with same wages. They should be provided with same salary. Now suppose if there is a factory. Now suppose friends, first condition that there is no law to enforce this DPSP. And there is a biscuit making factory in which there is a woman and there is a man. Now man is making 500 biscuits a day and woman is making 500 biscuits a day. Then also the owner of the factory is providing 200 rupees as the wages to the man. But the same owner is providing only 100 rupees to woman. Now even if this is the violation of Article 39 Clause D, then also nobody can do anything against that factory owner. Okay, why? Because DPSP are not automatically enforceable. But when government made law, okay, so inspired by this directive principle of state policy, Parliament made Equal Wages Act. So now if any factory owner or any person will not give equal wages for equal work, then he will get punishment. Okay, so this was the meaning of sixth difference. Now the seventh difference is that fundamental rights aim to prevent the state from becoming arbitrary or authoritarian. Okay, but DPSP aims to bring welfare oriented state. So what is the very basic aim of fundamental right? So the very basic aim of fundamental right is to stop the state, is to stop the government, is to prevent the government from becoming arbitrary. Arbitrary means is to stop the government from doing whatever government wants. So fundamental rights actually stops the government, prevents the government from doing whatever government wants. Okay. For example, friends, Article 22 says that Article 22 says that if a person is being arrested by the police, then police has to tell the ground of arrest. Means the person has the right to know the ground of his arrest. Okay. Further, the person has the first of all person has the right to know the ground of his arrest. Then police cannot arrest any person only on the ground of suspicion. Means police has some proof with him. Okay, police has some proof. Police cannot arrest any person only on the ground of suspicion. After that, the arrested person has the right to consult the lawyer of his choice. The person has the right to inform his family members about the ground of his arrest when he is being arrested. So what is police? Police is also a state. Police is also a state agency. Okay, so what fundamental rights is doing? Fundamental rights are simply putting a limit or a barrier on the powers of state. Fundamental rights are putting a limit or a barrier on the powers of police. Okay, means fundamental rights are stopping the police or the state from becoming arbitrary. Okay, for example, Article 22 stops the police from arresting a person arbitrarily, from arresting a person without telling him the ground of his arrest. So according to Article 22, police has to tell the person the arrested person has the right to know the ground of his arrest. Arrested person has the right to get defended by the lawyer of his choice. Police cannot arrest any person only on the basis of suspicion. Okay, so what Article 22 is doing? Article 22 is actually putting a limit on the powers of police. Article 22 is stopping the police from becoming arbitrary. So it means that very basic aim of fundamental rights is to prevent the state from becoming arbitrary or authoritarian. But friends, the aim of DPSP is to make India a welfare state. The aim of Directive Principles of State Policy is to make India a welfare state. For example, Article 38 itself says that state shall try to promote welfare of people by securing a social order in which social, economic and political justice shall prevail in all the institutions of national life. So what Article 38 is saying in short? So Article 38 is saying that government should try to make India a welfare oriented state. So the very basic aim of Directive Principles of State Policy is to make India a welfare state. Then comes eighth difference. So what is eighth difference? So courts are bound to declare a law unconstitutional and void if it violates any of the fundamental rights. But friends, courts cannot declare a law unconstitutional on the grounds that the law is violative of Directive Principles of State Policy. Now what does it mean? So it means that suppose if Parliament made a law, okay, and if that law is violative of any fundamental right, then courts are bound to declare that law invalid. It is the duty of the court to declare that law invalid. But if the same law is violating any directive principle of state policy, then courts cannot declare that law invalid. Okay, for example friends, suppose Parliament made a law and now that law is violating right to the freedom of religion, and now we all know that right to the freedom of religion is a fundamental right. So now it is the duty of the court to declare that law unconstitutional, invalid and void. But suppose friends, now the same law is violating Uniform Civil Code. Now what is where Uniform Civil Code is given? So Uniform Civil Code is given under Article 44, and Article 44 is a directive principle of state policy. So now if same law is violating Uniform Civil Code, then court cannot declare that law invalid only on this ground. So this is the meaning of eighth difference. Now what is ninth difference? So fundamental rights are given in strict legal language, whereas directive principles are given in very general language. So what does it mean? So it means that the language used to make fundamental rights is very strict and legal language, whereas the language used in directive principles of state policy is very simple and layman language. Okay, so you can check this by reading the language of fundamental rights and DPSP. Okay, now friends, with this your topic of directive principles of state policy is completed now. Okay, so now let's move further. So friends, then comes Article 350 capital A. So what Article 350 capital A says? So it directs the states and local authority within the states to provide adequate required facilities for instructions in mother tongue at primary stage to children of linguistic minorities. Now what does it mean? So friends, I will give you one example so that you can understand it very easily. Suppose friends, we know that Uttar Pradesh is a Hindi speaking state. Okay, means the people who speak Hindi are in majority in Uttar Pradesh. Now suppose friends, 500 people who speak Tamil language, they are living in Uttar Pradesh. Okay, so 500 Tamil speaking people are living in Uttar Pradesh. Now definitely as the people speak Tamil, so they are okay, and their population is only 500, so they are in minority there. Okay, so now these Tamil speaking people will become linguistic minority in Uttar Pradesh. So now Article 350 capital A gives orders to the government, give order to the state and the local authorities, okay, to provide adequate required facilities. Adequate required facilities means to provide adequate number of schools, adequate number of teachers, okay, for instructions in mother tongue at primary stage of the children of linguistic minorities. Now what does it mean? So definitely these 500 people, 500 Tamil speaking people are living in Uttar Pradesh, and many of them must be couples also, okay, and definitely they will give birth to many children. So many of them must be couple and many of them will give birth to children. So now it is the right of their children, okay, so it is the right of their children to get primary education in Tamil language only, okay, so it is the right of their children to get their primary education in Tamil language, and it is the duty of the state and the local authorities within the state to provide adequate number of schools, teachers and other infrastructure to provide these students education in Tamil language. So this was the meaning of Article 350 capital A. Means it is the duty of state and local authorities within the state to provide primary education to the children of linguistic minorities in their mother tongue. Now friends, this article promotes culture and education. Why? Because definitely in this way their culture and their language is preserved and they are also getting education in their mother tongue. Okay. So let's move further. So then comes Article 351. So what Article 351 says? So it directs the government to promote the spread of Hindi so that it may serve as the medium of expression for all the elements of composite culture of India. Now what does it mean? So in simple words, it means that government should spread the use of Hindi. Okay, government should spread the use of Hindi, and every person in India should know how to speak Hindi. Every person in India should speak Hindi. So this was the meaning of Article 351. Then it says that definitely the language of South India, East India and other parts of India is different. Okay, so it means that whenever people from East India, West India, North India, South India, Central India and any part of India want to communicate with each other, then these people should use Hindi as a medium of their communication. Now friends, a very basic question arises that why only Hindi? Okay, so why Article 351 says why Article 351 gives order to government to promote Hindi and why not English? Okay, so why only Hindi and why not English? So the first reason is that it is known to more number of people. Okay, so Hindi is known to more number of people. Why? Because first of all, Hindi is the language spoken in North India, and in North India the population is more than South India. Okay, so Hindi is known to more people. And definitely friends, all people in South India and East India and other parts of India, they also don't know English. Okay, so only literate people, only people who have done their education in English, only these people know English. For example, a beggar from South India, he doesn't know how to speak English. He only knows how to speak his mother tongue. Okay, similarly, a vegetable seller, a fruit seller, they also don't know how to speak English. They only know how to speak their mother tongue. Okay, so it means that Hindi is known to more number of people. Then the second thing is that Hindi is a indigenous language. Indigenous language means Hindi is a language of Indian origin, but English is a foreign language. Okay, English is not a Indian language. So the second reason is Hindi is a indigenous language. And the third reason is that, friends, according to Mahatma Gandhi, father of our nation, English creates divide between few people who know English and masses who don't know English. Okay, so English creates divide. English divides the people. Okay, for example, only few people knows English. Okay, and masses don't know English. So English creates a divide between them. So English is not good as a medium of communication in India. So Article 351 does not prescribe for the use of English. Article 351 prescribes for the use of Hindi. Then comes Article 335. So what Article 335 says? So friends, it directs that the claims of scheduled castes and scheduled tribes shall be taken into consideration constantly along with the maintenance of efficiency of administration while making appointment to the services of the government. Now, what does it mean? So friends, definitely we all know that SCs and STs means scheduled castes and scheduled tribes are educationally and socially backward. So definitely they need protection. Okay, so whenever there is a appointment in government service, whenever there is a vacancy in government service, then they need some sort of protection. Why? Because they are educationally backward, also they are socially backward, so they need protection. So Article 335 directs the government, means it gives order to the government to take into consideration their claims whenever there is a vacancy for government job. So what government does? So definitely government provides them reservation, and through reservation they comes into government job. So this is very simple. Now friends, further Article 355 instructs the government to maintain the efficiency of administration. Now what does it mean? Okay, so I will give you one example so that you can understand this very clearly. Now suppose friends, in any state of India, there is a post of SDM. Who is SDM? Sub-district magistrate. Okay, and for example, we all are preparing for IAS, Indian Administrative Service. You all are preparing for IAS, Indian Administrative Service. And SDM is a officer of State Administrative Service. Okay, so you will become collector, and SDM is a post just below collector. Okay, so collector is a DM, district magistrate, and SDM is a post just below DM, sub district magistrate. Okay, now friends, there is a post, suppose there are 10 vacancies for SDM in a state. Now 6 seats are available for general. There are total 10 vacancies. Out of these 10 vacancies, 2 seats are reserved for the candidate of SC category, 2 seats are reserved for the candidates of ST category, and 6 seats are available in general category. Now suppose the paper is of 200 marks. Okay. Now friends, there is a disclaimer. The disclaimer is that I am not in the favor, or I am not in the favor of any community, and I do not criticize any community. I am just giving you the example so that you can understand this concept. Why? Because here your aim is to clear UPSC. Okay. So friends, now suppose that the paper is of 200 marks. Now the topper from general category, he scored 190 marks. Okay. The second person scored 185 marks. Similarly, the third person scored 180 marks. Then next person scored 175 marks. Then next person scored 172 marks, and the last person scored 170 marks. Okay, so first person scored 190, then second person scored 185, then 180, then 175, then 172, and the last person scored 170 marks. Okay, so the minimum marks scored by the candidates of general category is 170. Okay, now suppose friends, on the other hand, the persons from scheduled tribe category. Okay, so the person who scored the highest marks, from ST category, he has got only 40 marks. Now suppose a person who is getting only 40 marks out of 200, can he be a good administrator? Can he be a good administrator? Okay. Will he be able to take good decisions in the while he is on duty? Okay. So will he be able to take good decisions for public? So definitely he is not a abled person. Why? Because he is only securing 40 marks out of 200. Okay. Means he is only scoring 20% marks, and a person who is scoring only 20% marks, will he be able to take good decisions? No, means the efficiency of the administration is not maintained. So now what government did? Government introduced cutoff system. Now what is cutoff system? So according to cutoff system, now the cutoff for ST category is suppose 150 marks. So if any person will score below 150 marks, then he will not get appointment under the service. And the people who will score more than 150 marks, only they will be appointed under the service. Okay, means even if you are getting reservation, even if 2 seats are reserved for ST category, then also the candidates from ST category has to score at least 150 marks to get selected. So now definitely the efficiency of administration is maintained. Why? Because a person who is getting 150 marks out of 200 marks, definitely he is an intelligent person. So he will be able to take good decisions in the nature of his public duty. So this was the meaning of Article 355, that government should take into consideration the claims of scheduled castes and scheduled tribes. But government should also maintain the efficiency of administration while making appointment in the services of the government. So friends, that's all for today. Now today's lecture is little short because from next class we have to start a fresh topic, and that topic is the President of India. Okay, so from next class we will continue our discussion with the President of India. So friends, I hope that you all must have enjoyed the lecture, and if you have enjoyed the lecture, so please like the video, comment, subscribe to my channel, press the bell icon, and share this channel to as many people as you know who are preparing for UPSC or any state PSC. Till then, take care of yourself. Thank you.